before we get started, I would like to add a few ground rules. I'm sure most of you heard these earlier. The workshop is about fair housing, not just housing. We are focused on bias, discrimination, and disparate impacts in buying or renting a home or related to credit ratings or mortgages. We would like to end this session with 2 to 3 specific policy recommendations for moving fair housing forward. We welcome comments with potential solutions for the issues being discussed today. Please keep discussions focused on the topic for this discussion. For example, we are unable to address individual complaints or circumstances in this session. We are focused on broad policy discussions today. We will not tolerate inappropriate, inflammatory, or disrespectful behavior or language, and I don't anticipate any of that today. And you will be warned and then asked to leave if we do perhaps experience any of those behaviors. While we could discuss this topic all day, our time, oh no, that is the end, I am sorry. Before we move into the discussion though, just to get a sense of who's in the room, we have these fun little tools in the middle of the table. How many of you work for a fair housing organization? You can indicate with the green thumbs up or the red thumbs down. All right. How many people in the audience work for a local governmental agency? Okay, all right, okay. How many have attended a zoning workshop in the past? Okay, all right, so it's kind of mixed. That's all right, awesome. And how many of you have had zoning decision making in your work or personal lives? I'm going to say we should see a lot of green there. And how many of you have seen or read about local community opposition to affordable housing? All right. So then it sounds like we're ready for this conversation. Sarah, I pass it over to you.
Great. Thank you so much.
Thank you.
Hi, everybody. Everybody hear me okay? If I stand up, don't be surprised. I have a hard time sitting still. Don't ask. So Dan Lauber could not be here today. He came down with terrible back problems 2 days ago, was all ready to go, and we went to every single preparatory session for this. So he asked me specifically, the slide's not up anymore, there was a link on Dan's website with his presentation, and I'm gonna, since the slide is no longer up, I'm going to give it to you, hold on.
Oh, they put it back up for you.
There we go, www.grouphomes.law, okay? And he said that that his presentation would be there on his website. He has a whole website on zoning issues and planning issues as they relate specifically to group homes, sober living, and housing for other people with disabilities. And he was very sorry and sends his apologies for not being able to be here. But nonetheless, Dan and I have worked a long time in the same field. I will say that we have a certain amount of disagreement about the way municipalities should provide housing for people with disabilities, and I'm going to talk generally about some of those issues as part of my presentation. So although I'm going to talk about exclusionary zoning writ large, I'm going to talk about race, I'm going to talk about national origin, I'm going to talk about disability as well. And y'all feel free to ask me questions. As you'll hear in the presentation, I've been involved in litigation on zoning relating to sober living homes and community integration for people with disabilities. I sued the Dallas Housing Authority a few years ago. So any of the questions you want to talk about that relate to any of those topics, you're going to feel free to do that. And we'll have plenty of time to talk. And I really want you to ask me questions, because if you don't, I'll just have to keep talking, and really I get boring after about 45 minutes. Okay, put up the other PowerPoint for me, will you? And let me get started. My work in fair housing goes back 47 years. I'm much older than I look, I hope. But zoning has been a thorny issue in our civil rights work for many years, and it's particularly today. And we use civil rights laws to challenge zoning decisions. And personally, I think that's because we're finally getting around to dealing with structural racism and structural exclusion and structural discrimination. And so while exclusionary zoning cases can come up from individual situations, one developer, one group home, it is also becoming a more systemic issue which communities are looking at in more in broader ways, to try to look for solutions to see how they can address structural racism embedded in the community. And we're going to talk about some of those issues as part of identifying what the problems are and then what are some of the solutions, okay? So that's the overall approach we're taking in this training. And so there we go. Lots of words, and you can read it or you can listen to me, whatever you prefer. So again, this is a hot topic. Zoning is a hot topic. We're involved, my firm is involved in zoning cases all over the country. We're a national civil rights firm based in Washington, D.C., take on cases all over the country. And we're going to talk about zoning decisions as it impacts affordable housing, multifamily housing, single-family housing, including affordable single-family housing, manufactured housing, and smaller residential-based housing that might include group homes and the most integrated setting for people with disabilities. Because all of those kinds of housing are affected by the zoning rules in effect in many communities. And I'll say one other thing sort of as a prelude to my discussion, which is larger communities have started revamping their zoning codes to be consistent with the Fair Housing Act, either because of lawsuits, HUD complaints. The U.S. Department of Justice has filed a number of zoning cases, private litigation, HUD complaints, and all the rest. But a lot of smaller communities have not yet been touched. And in my experience, just in my limited experience at my law firm, we have heard inquiries about Detroit, Lansing. We sued Howell, Michigan, over local zoning decisions, and we've looked into another number of other examples as well. Smaller communities seem to be slower to change than larger communities and tend to only change when they're pressed, threatened with lawsuits, actually sued, or where there's a judgment in the lawsuit against them. And those kinds of cases go on all the time, all over the country. There was a case that my firm practiced in Connecticut a few years ago, a exclusionary zoning case, where a town got wind that a small residential setting, single-family house that was going to be used, sober living, for opioid addicts who were out of recovery and needed a place in the community to transition back in, right? So this is very common. You have somebody with disability, they're in rehab, they have come out now, they're found basically ready to relive in the community, but they don't have a place to live, or they need a very stable place to live, often with their peers, and maybe with one person in the home sort of as overseer. And they go back, they have jobs in the community, they live there while they work through their transitional phase, and then they're off on their own. Very common. And so in that case, the mayor got wind of it, called a town meeting, which they had never had before in the history of the town at that stage of the zoning process, to get community input. So of course the community turned out and yelled and screamed and hollered and carried on about this, and then and opposed using this residential home. It was a beautiful brick home in a residential neighborhood. It had 5 bedrooms, which is kind of a good size, big yard, nice whatever. None of these guys had cars, so there was not a traffic problem. They lost their driver's license somewhere along in their journey, right? And, but the community just didn't want those people in the neighborhood, and they said so with a lot of pejorative language toward people with disabilities, drug addicts, et cetera, et cetera. So the mayor had this hearing, got all this community opposition, and then the community embarked upon a process of doing everything they could to slow the process down or to disapprove. So they told the applicants that they would have to go through a special application process and request a variance to allow the group home to operate in the neighborhood. A group home in a residential setting that's going to serve 8 or fewer people does not need any approvals from a local community. Now, a local community can set up a process for them maybe to register as if like they're a boarding home or something like that, But basically, they don't need any approval to move in. But the mayor was sure that they needed some kind of really important, complicated, expensive application process. And so they started in that process. They made an application. There was going to be some hearings in the zoning commission, this, that, and the other. And the opposition showed up at every meeting, right? And then the mayor decided he didn't have the votes on city council to defeat the variance. So he put a moratorium on for a year of no more group homes in the community. Now, there weren't but 3 already in this community, but they put a moratorium on them, and while they rewrote their zoning ordinance. And these applicants didn't have a lot of money at that point and didn't have representation, and so they just kind of went, oh, we guess we'll wait. And they just waited, put off delaying this, and it was a very hard thing for them. The woman who was founding and starting the group home had never done anything like this before. She wasn't a big corporate entity. She wanted to start the group home in memory of her sister who had been addicted and who had died. And so it was, really a very touching and tender kind of process they were using. And so the town put on this moratorium, and it lasted a year, and then they came out with a new zoning ordinance that was just terrible. And it called for certain requirements to be put in place, burdensome requirements in terms of what had to be provided at the house, required a special hearing process, et cetera, et cetera, et cetera. And we sued. By then, they'd come to see us, and we sued. That lawsuit resulted in get this, the town manager and the mayor were the 2 entities, and the town manager was carrying out the instructions of the mayor, we're pretty sure. The jury returned a verdict of $5 million personally against the town manager for his conduct in that situation. Wow is right. Now it's on appeal. I have to say, I'm a lawyer, you get used to this. You win one, and then it goes on appeal, and you get 3 steps back, and then you do some more dancing, and then maybe you get a few steps further. But the point is, what a message. This was not a big town. Maybe, I forget, 35,000 or something. That's a lot of money, right? And so we use that as an exemplar when we talk about zoning things to talk about, what happens when the community's not listening to the civil rights laws and instead is listening to opponents. Okay, can we go back to the PowerPoint? So we have all kinds of claims that can come up in zoning and land use cases, and this is just a summary. It applies to all kinds of housing, can get caught up in the zoning process. You can have a zoning system that itself discriminates, and sometimes it calls out certain kinds of housing for people with disabilities for special, adverse treatment in the zoning code itself. So, or there could be a system of a zoning process that requires extra responsibilities and burdens on the entity that's running a group home that is almost impossible to meet if you're going to run a small group home, and expensive. Like, let's put in, you must have exits from the 2nd floor. Emergency exits from the 2nd floor is one example. You wouldn't have that in your own home, 2-story colonial where your family lived. Even if the baby slept on the 2nd floor, you wouldn't have a separate fire escape from the 2nd floor. But they would put those kind of obligations on group homes for people who are grown adults and can walk down the steps themselves or run out the window or even jump out the window without too much damage. There's also decision-making that goes on in individual circumstances when somebody comes in and says, we want to do this, we want to start this, we want to have affordable housing in this neighborhood, and the individual process triggers community opposition or triggers outright community opposition, or triggers local zoning and planning commissions and city councils and other governmental entities to impose barriers against that kind of housing and end up with adverse decisions. Question already? Go ahead.
It's just a very quick question. I think the answer is yes, but I just want to make sure. For who can be a plaintiff in these kinds of cases? Fair housing centers can be plaintiffs, just like any other kind of fair housing claim, or is zoning?
Yeah, I'll repeat the question. Who can bring these cases? Is it fair housing centers? Yes, it is fair housing centers. Is it the group home themselves, the group home that wanted to start this? Yes, indeed. A group home itself, an operator of a group home or a chain of group homes can bring the case. Technically, and even a potential resident in that group home could bring the case, but it's not very common for them to do so, usually because the potential residents haven't been identified yet. They're still in rehab, and you're setting up the home for them to come to, out of rehab. But I've seen cases brought by all of those. There's a group called Oxford House that runs group homes in communities for recovering alcoholics and drug addicts. And they have a particular model that they use that does not have a caregiver on site, but has adults in shared living settings in single-family residences across the country. They have brought a number of lawsuits as well. So there you go. And there are a few other options. Can we go on, keep the slides up and go on to the next slide, please? So the way the Fair Housing Act applies to zoning is really well established, and it's been established as one of the very first things, big decisions, the second case that went to the Supreme Court under the Fair Housing Act is this case called United States versus the Village of Arlington Heights. Village of Arlington Heights was an all-white suburb of outside of Chicago. Chicago had a significant black population, and it was an all-white residential single-family suburb caused by white flight. Let me just be real about that, okay? And a developer got some money from HUD to develop affordable, subsidized rental apartments in this community that would mostly house people of color, black people specifically in Chicago in that particular time. In 1975, 74, 75, 76, that case was filed. And what happened was the developer could not get zoning approval to change the zoning from residential single family to multifamily. It's pretty straightforward. And this case has become the linchpin for thinking about ways to challenge zoning ordinances still in effect today, still applied today. A good friend of mine worked on this case when he was a young lawyer. He's now retired as a retired law professor, and he still talks about this case, and I still talk about it because it's such an important framing. So understand the Village of Arlington Heights case. If you don't remember anything else, remember Village of Arlington Heights. Next slide, please. Okay, so the Arlington Heights case it went to the U.S. Supreme Court on a constitutional issue, and they sort of tossed it back and said, we don't see a constitutional issue, but maybe there's a Fair Housing Act issue in Arlington Heights when they turned down this. And the Seventh Circuit Court of Appeals said under the Fair Housing Act that the municipality had a statutory obligation to refrain from zoning policies that effectively foreclose the construction of any low-cost housing within its corporate boundaries. Flat out says it. Okay, so we have this zoning concept, takes on zoning directly and says discriminatory under the Fair Housing Act. So the idea here was there was a site, it was in changing it from single family to multifamily to allow a subsidized apartment complex there. Arlington Heights was pretty much all white, Chicago was pretty much all black. Well, not pretty much all black, but certainly the residents of this house were likely to be, who would qualify were most likely to be people of color. This was an impact case because the impact was to exclude people of color. But it became known because it was also intentional. So they didn't say, we don't want blacks. What they said was, and what the court analyzed was how they handled the situation. So the bottom line is, here's this court decision saying Congress didn't mean, and passing the Fair Housing Act didn't mean that you could deprive minorities of housing opportunities simply because they're discrete. Right? So they didn't say anything about race. They just did stuff that was discriminatory. So let's, next slide. Oh, wait a minute. I know how, I can move that forward myself. Okay, there's intentional discrimination. So let's talk about intentional discrimination because we always, even in today's world, they either say it or they almost say it, or they signal it, either by their words or by their conduct. And we're not always attuned to the signaling part of it, and I want you to become more attuned to the signaling part of it. So here are some things that can show, according to the courts, that something is intentionally discriminatory. So first of all, the fact that they're doing something that actually is intentionally discriminatory does not have to be the only factor. Courts today are trying to cut back on that, but the case law says it has to be just a motivating factor in the decision. So if the opposition talks about race and talks about national origin, and then they also talk about traffic, race doesn't have to be the only reason. And the question is, what was the motivation for what they did, what they finally did? And so courts don't have any problems finding in most cases it was not about traffic. And more about that in a minute. It was really about race. So overtly discriminatory remarks made by opponents in the audience, in those hearings where the mayor is there, or the city council is there, or someone else is there talking, taking minutes, and they say stuff. And sometimes they are quite overt. I had a case once where the planning official said, we don't want any more Mexicans in our community. Flat out said it. If I needed further evidence of national origin discrimination, I don't know if I did. I would say, in that case, we got more because we thought he would deny it later, that he had said that. There were witnesses, but it was not recorded. He didn't say it in writing. We're lawyers, so of course we think, how else are we going to prove this if he lies and says he didn't say it? But also use of code words, and we're going to talk about code words in just a second, because more and more courts are willing to understand that people say discriminatory things without being openly discriminatory, but they convey an intent that is discriminatory. And I want to give you some of those examples because they are really important in thinking about what happens in community opposition to affordable housing, whether it's affordable stick-built housing, right, single-family housing, whether it's affordable and subsidized housing like tax credit housing or some other form of housing, maybe in a rural area it's USDA-funded rental housing, or whether they're talking about even manufactured housing communities and opposing manufactured housing communities or their expansion in local communities. So discriminatory opposition from the local community can be imputed to the decision makers. So if they have 3 public hearings for public input and everybody comes in screaming about we don't want those people and this, that, and the other, and they maybe yell about traffic and burden on the schools too, right? That, if to the extent that that commentary is 1, discriminatory, and 2, likely to be unsupported by the evidence, then that when the city council votes against it, it's assumed that they heard the community input. The discriminatory attitudes of the community are imputed to them, okay? And so this goes back, again, to the 70s, right? So this was people who were smart enough to know that you don't have to open your mouth and say racist stuff if you're the decision maker, if everyone around you is saying stuff that connotes discrimination. Obviously, these discriminatory actions, whether that's adopting a code, applying a code, or changing the rules, can all be challenged both at the individual level, bottom up, or from the systemic level, looking down on the process and seeing what it has accomplished. So look at these code words. I mean, these are all the kind of things that have been viewed by enforcers as being discriminatory. No public housing. There was a big HUD complaint filed by Amy Nelson's office in Indiana. You just heard her talk not very long ago, where the words no public housing was written into a local ordinance in a rural part of the community that said no public housing could ever be built there. So here's a question for you. Who lives in public housing? 1, poor people, and 2, people of color, right? So no public housing, no Section 8, subsidized is a code word too. And so, by the way, if you ever run into a situation where where affordable housing tells you they can't get insurance for their property because they're subsidized in that context is code word for black. And my firm has brought cases, and so have other people, against homeowners, liability insurance companies, Lloyd's of London, Aetna/Travelers, and others, for this policy recently that where the big insurance companies are saying they won't insure subsidized housing because we think there's a racist underpinning and that subsidized housing is code words for blacks or people of color, depending on what part of the community you live in. The units will be overcrowded. This is a national origin code word specifically, but it can be a race code word too, depending on the circumstances. Just the automatic assumption there will be too many people living in the unit, they'll be overcrowded. Decrease in property values. Listen, I've been doing fair housing work since my first fair housing conference in Detroit in 1977. How many times have I heard it'll decrease the property values? There's a fabulous book written about this kind of claim around Mount Laurel, New Jersey, which had a huge fight, community fight, over placing affordable housing there. And everybody said it was going to decrease the property values of the single-family community around it. I visited that property today, however many years later, 20 years later maybe, after it was started. And the property is beautiful. All the surrounding neighbors are beautiful. And research shows that, in fact, it is quite unusual, in fact, almost never happens, that surrounding properties will experience a loss of property values because affordable housing comes in the community. But people still say it without evidence. The property must be upscale. Read, no poor people for us, and by the way, no people of color either. There'll be an increase in crime. There'll be a ghetto. I've heard ghetto used a lot. We talked about it maybe in one of the sessions this morning. The quality of the community will go down. In Florida, this year, I heard community people saying, we want to retain our community character, which appears to be mansions on 1-acre lots. And what kind of character is that? I just want to know. But my point being that, people say all kinds of stuff, and they say it because they don't want to say out loud, we don't want blacks in our neighborhood, right? There'll be too many kids. Again, this comes up a lot. And one of the most common examples of actual discriminatory practice in zoning decision making is a developer comes in and says, I want to develop affordable family housing in this neighborhood, which is white neighborhood where the Target is and the Walmart is and the new high school is. That's a Grand Rapids example if anybody doesn't recognize it. And the community rises up and says there'll be too many kids. There'll be a burden on the schools. They say that all the time, and then the zoning process may say, well, we'd love for there to be some affordable housing out here, but let's just make it for seniors instead of for families. Because somehow senior housing is considered to be less threatening than housing for families with children. Usually the burden on the schools argument is not supported by evidence, but if you're an investigator, you got to go find out. If they say there's going to be a whole bunch more kids and they'll be going to the schools, fine, you have to get an estimate for how many kids there might be in this property. By the way, a lot of multifamily housing does not actually have that many families with children. And if it's a big space, single-family neighborhoods tend to have more children. Why is that? Because people who live in apartments tend to be moms or couples with 1 or 2 or 3 kids, and after that, the apartment's too small, and they do everything they can to buy a place. So single-family housing actually has proportionately more families with children in some communities than the apartments do. A lot of talk about undesirables. We don't want these people. These people in a court case has actually been read to understand to be black people, right? Because of the context. And so what we have is a lot of conversation around these issues, and it's really classic example that people will say all these things in hearings, and maybe one thing that they say in opposition will have a small nugget of truth in it, and everything else just cannot be supported by facts. And even the one nugget is like, for example, burden on the schools, burden that some of the schools in the neighborhood were crowded, but the ones that were overcrowded were middle schools and high schools, and the projection was that people who would be living in these properties would be elementary school students, and they weren't overcrowded. So these are the kinds of things that if you were an investigator, you would try to find out about during the course of an investigation. If you were the person who wanted to live there, you would be helping to figure out what people say in these hearings, how to get it recorded, how to get it identified, and then investigating for yourself even what all the little explanations that they were giving for their opposition and whether there was actually evidence to support it. All right, I've lost my slides again. Here we go. All right, we doing good so far? All right, code words. Now, part 2 of intentional discrimination is, so the first part is people either say discriminatory things or they say code words from which you can find discrimination. That's part 1. But we're always lawyers, so we also evaluate the case to see if there's other evidence of discrimination. And a second kind of way of showing discrimination came out of the Village of Arlington Heights and says there's a series of things where it just gets weird because certain things have happened. The sequence of events that led up to the zoning decision is really weird. It was not the usual process. It had fits and starts. It stopped. They had to go for a moratorium. They had 14 meetings with their lawyers. They turned it down once, and then they said you could do it if you do some more things, and they went and did some more things, and then they said no again and said you had to do some more things, which is not your typical process. The legislative or administrative history, again, fits and starts. They're treating this affordable housing project differently than other projects for, say, that were not affordable housing. For an apartment complex across the street, made a real case once about the fact that the affordable housing that was going to be built on one street was completely differently treated in its process than the brand new apartment complex that was just built 6 months earlier across the street was not affordable, right? And which was going to have a wider population than the affordable housing. You look for changes from the normal procedure. So you look at the ordinance and see what the normal procedure is, or you see how the county or the city has handled the situation before, and then you see if they've changed it for this one. Because in these cases where there's discrimination, there's suddenly delays. They can't meet. They can't have a public hearing that's required by the ordinance for 6 months because the commissioners are going to be out of town. I mean, all kinds of BS, I'm just going to say. You look at the historical background. When I recently wrote an analysis of exclusionary zoning in a South Florida town, we included a part about how the town had been a sundown town in the early part of the 20th century, that it was a town where black people could work and shop but could not live in like 1910, 1920. It was a town that had a history of KKK activity, recent history of KKK activity. And so when you get this kind of evidence of opposition, then that becomes part of the history of the town, and you can use it not as evidence that they were discriminating exactly, but as piling brick upon brick upon brick to show it's more likely than not that discrimination occurred. Evidence of community opposition, we've talked a lot about that because in a lot of communities there is this community opposition with people using code words. And the impact of the action, and that's where you can say in subsidized housing, you do your homework. If this is housing that is available for people at 30% of the area median income or lower, which means for very low income people, you do your research and find out who that population is in the community, and you say, oh, look, it's disproportionately black in this community, right? And that's how you show impact. Okay, so if you show all of those things or most of those things in your evidence, then the courts will say, we don't see much evidence of direct, overt intention or code words, but this whole process is really screwed up. And we really think that this is unusual, and we think it's most likely, or more likely than not, that it's caused by their intent to discriminate. So it's not open intent, it's inferred intent from all these things happening that are weird and strange and make it a lot harder to get through the process. Okay, so far? I'm using that theory, by the way, in a lot of cases right now where people don't say stuff out loud, but they do weird things to get, like from renting to somebody or from having a contract, say, with a domestic violence shelter to house victims of domestic violence, and I just can't do it, and this, there's this whole delay, denial, they're not returning my calls. At some point, you add up and you look at all of those elements, and maybe you've got an intentional discrimination case, again, even though they don't say it out loud. All right, so let's see, we're already to there too. Part 3 of intentional discrimination. Intentional discrimination can just be unequal treatment. So again, they've treated the last 4 apartment complexes that have come in for permission to build new apartments in a certain way, and now the 5th one comes in and it's affordable housing, and all of a sudden the rules change. That's just unequal treatment. And we've always known in civil rights cases that housing that is more likely to house people of color than other housing may be treated differently, and where you have that evidence, that's unequal treatment. So it's not that hard to prove, except sometimes you don't have comparisons. You just don't, it's a new place, they don't have a new property, any other properties built. The last similar process that wasn't affordable went through 5 years ago, and it's not really a good comparison for those of you who are looking at this. So you don't have unequal treatment. You go back to your intent, either overt intent or that inferred intent. Or you go forward to disparate impact. So many of you have heard about disparate impact. You heard about disparate impact in fair housing cases a few times. Impact discrimination is not intentional, it's unintentional. I didn't mean to discriminate, and you can believe them all you want to. The question is there a policy or a practice or a decision that is not overtly discriminatory, facially neutral, it just applies to everybody, and it's applied consistently, all right, it's not applied unequally, so they're knocking out intent, it's not intentional, but somehow the application of this policy has the effect of excluding housing that's going to house people of color in the community. So it doesn't look, and this is the really highly paid lawyers and sophisticated decision makers in bigger cities may adopt as a standard that is sort of, that has a disparate impact, but it doesn't look like intentional discrimination. And that's what you have to watch out for and identify. So the evidence would show that there's a greater negative impact on one racial or ethnic group than on another. And so the policy is neutral, applied consistently, still has a disproportionate impact. So what is a policy or practice that has a disparate impact in zoning? Anybody got an idea? What? Felony conviction. Okay, except that doesn't come up much in zoning, but it could. Let's think about how it could. Developer is going to develop housing for recently incarcerated people, and everybody who's recently incarcerated is going to have had a felony conviction at some point in their life because they were incarcerated, right? So they say, we're going to turn this property down. And they're going to talk about crime and everything else. Turns out that everybody with the felony conviction was not involved in a violent crime at all, but were involved in some other crime. So they rejected the policy based on criminal background, but the impact of the policy was to disproportionately qualify housing that would house formerly incarcerated people. And there was a less discriminatory alternative, was to accept the housing, but only have them house people who did not have a conviction for a violent crime. Done. You, yeah.
So townships will implement zoning restrictions against farm worker housing, and all farm workers are Latinos, virtually all are Latino, and that's a way of getting those people out.
Absolutely. And there are actually several properties where there's been exclusionary zoning to exclude farm worker housing, often considered to be temporary housing, and they call it farm worker housing and temporary housing, but who it houses is farm workers. Farm workers are Latino, so disproportionate impact on people of one particular ethnicity, violation of the Fair Housing Act. Lee versus, let's see, what is the name of it? United States versus Lee County, Florida, is a ban on farm worker housing, exclusionary ban on farm worker housing that the Department of Justice proceeded with a few years ago that said that was discriminatory. And I worked on a case against in Kennett Square, Pennsylvania, where they said no more farm worker housing, and that rule excluded people from other countries who came to work on the mushroom harvest. So look out for that, because that is absolutely an example of a disparate impact. All right. So let's think about some of the impact issues that come up in these cases. No intent. How strong is the showing of the effect? So how do you show effect? If it's subsidized housing, you show who would be eligible for subsidized housing in the community. If it was discrimination because people had Section 8 vouchers, there's a policy that is not, is it illegal per se to discriminate based on source of income in Michigan? Who knows? In some cities, but not in the rest of the state. So assume it's not in one of those cities. And the community says, no, we're not going to approve this housing because Section 8 voucher holders are going to live there. And yet in that community, Section 8 voucher holders are disproportionately Black and Latino, and moms with kids, say. Right? So you build a case around that analysis and say that in that case, we can show impact because we have data about who's in the Section 8 population that would be affected by this. So sometimes it's census data, sometimes it's in the population that would be served, sometimes it's something else. Is there any evidence of discriminatory intent? And why did the respondent or the city or the municipality care? What was the justification, supposed justification? And if you're an investigator, you always have to find out what the justifications are, every single one of them. Go to every hearing and listen to every minute, read to every minute, and say, why did they say they were doing this? And then you investigate each one, right? So sometimes there's legit reasons. I wouldn't kid you. Sometimes there's legitimate reason. Suppose you've just approved 6,400 affordable housing units in one community, and you've just decided enough is enough already, and we are going to build single-family affordable housing instead of having rentals, because the real need in the community is for home ownership, say. And so you can have a justification for, say, cutting off decision-making on the rental, even though there's land and all of that other stuff. But it better be a good justification, and it better stand up to the kind of exacting scrutiny that a good investigator would put to it, right? All right. So we also look at the question, and we're still sort of thinking about principles that come from this old Arlington Heights decision. The fact that the conduct that is complained about still has some impact on white people or people in some racial or ethnic group other than the group that is protected is not by itself an obstacle to a Fair Housing Act claim. That is to say, not all Section 8 voucher holders are black or Latino. Some are white. Some are other racial and ethnic groups in our communities these days. And so the fact that some people who were harmed by the process are not a group of one of the groups protected against discrimination in that particular setting is okay. You can still bring the case. You have a question?
Do these zoning, I'm imagining a situation where you have a zoning that is written to pretend to protect one group at the expense of another. So like the example I'm thinking of is we're not going to allow multifamily home development in this area because there's families with children who would come there, because there are group homes that are sober living homes within a certain distance of where the development would be, right? So it's like discriminating against two different groups in two different ways, but it's framed allegedly as a positive.
Yep. So actually there's some court decisions in Michigan about that, and what they say specifically is that the justification for your zoning decisions have to be real, and they have to be designed to protect the residents of the housing in issue, not protect against some supposed harm against someone else. I represented folks in a zoning case involving an AIDS hospice that wanted to be located in a particular community, and in Texas, curl of lips, scowl. And the local community rose up against it, and they were talking about the risk to the neighborhood. But there was no evidence of a risk to anyone else. And the protections they put in place were protections for the residents themselves, like hazardous waste disposal for medications and stuff. And so it passed the smell test. So you cannot use a hypothetical risk against someone else to justify discriminatory exclusion. I'm just going to say that flat out. And the disparate impact analysis that courts have used, and in the HUD regulation, which thank God I was permitted to work on, there's a line that talks about that the justifications that are offered cannot be hypothetical or speculative. You're welcome. All right, so more than that, let's see where I am. Okay, I'm doing good. The perpetuation of segregation, I want to talk a little bit about this, and then we're going to go back and talk about some specific examples. So the Fair Housing Act has two sets of regulations. One is a disparate impact analysis, and one is a perpetuation of segregation prohibition. You're not allowed to do things that perpetuate segregation. And again, it does not matter what your intent is. You might even have a good intent and say, I want to do this, but actually on paper, it looks like it's going to make it more segregated here and not less segregated here. What do we do about that? So the analysis says you cannot do either of those. You can't speak exclusionary discriminatory zoning, and you cannot perpetuate segregation. So you have to figure out, it comes up as a defense sometimes, just because we turn this one down doesn't mean we would turn everyone down, right? And so the answer is, one, it doesn't, you look at each case on its own merit, not on whether you were totally excluding that kind of housing from the community altogether. Because you don't have to do that to violate the act. You just have to take actions that result in a particular kind of situation being excluded. So you exclude one, that can be an act of discrimination. The whole policy doesn't have to exclude everybody for there still to be a violation of law. And so zoning rules may also keep segregation alive, right? So, for example, if you say in some parts of the neighborhood, you can't put public housing or low-income housing, and over here you're allowed to put low-income housing, what's the predictable result? All the low-income housing will go in the same neighborhoods that they've always gone in, and what will be the answer? There will be a perpetuation of segregation. Maybe this is a good time to mention, I got to ask a question. I'm just going to jump into this question right here. Someone wrote a question on the app. So I looked at the app, I read the questions like a good participant is supposed to do, and the question was, I'm going to paraphrase it. Said something like, we got a lot of money spent for tax credit housing, and tax credit housing has historically been placed in communities of color and poorer neighborhoods, and it's created segregation, or I think the question said apartheid, because all the tax credit housing has been put in these particular neighborhoods. And what is the solution for that in terms of creating more diversity? And there is an answer. Now, I'm going to give you the long version, so stay tuned. When the tax credit legislation was first passed in 1987, it was sponsored by Coleman Young. Is that his name? A member of Congress who had a specific issue he was trying to address. And that was the lack of quality housing in black neighborhoods. It was clear that was what the intent was of the origination of the program. But what happened and they started putting tax credit housing in place about 1992, got the program going and running, and for a long time it was the only housing production program in this country for affordable housing. HUD didn't get any money to make public housing bigger. HUD didn't get any money to increase the project-based Section 8 housing. There was vouchers and there was the tax credit program, and that was it. That was what Congress was funding. So what happened was, as a result, a lot of the early tax credit properties went into communities of color, and they did provide better quality housing, but they also perpetuated segregation and did not give the residents who were going to live there a choice of where to live, given that they needed affordable housing. And so in today's world, we think more about siting issues, and we look for opportunities to site affordable housing in areas that are non-traditional for tax credit property, so people can have choices. So let's put some tax credit property, some units out there next to the Target and the Walmart and the new high school and the white neighborhoods. Let's put some tax credit property in this middle income area with the good schools. And yes, let's consider putting tax credit housing back in communities of color, but let's mix it up with economic development. So do mixed income housing, or put in economic development. Let's put a CVS on the ground floor, and let's put a few market rate units, and let's put some tax credit properties in. So tax credits originally were supposed to have 30% affordable units, and the remainder of the units were market rate. That was where it was supposed to work. But because tax credit properties couldn't exclude people who had low incomes or who had a Section 8 voucher, ultimately they ended up being communities that were entirely black. And so if you're going to invest in a neighborhood, you invest. And lots of black communities have not had good quality and economic investment in them for years, if ever. And so the balanced approach says we're going to, for example, tax credit properties are managed through state housing finance agencies. Anyone from a housing finance agency here? They should be here, and y'all should be talking to them. So the housing finance agencies in some states give point systems to developers, and you're trying to get as many points as you can. So I once did training on accessibility and non-discrimination for tax credit people because they got 1 point credit towards getting their tax credits if they came to my training. And the room was packed because everybody is fighting for the tax credits and everybody wanted to get that extra point. So you could give an extra point for tax credit housing that was going to serve a non-traditional neighborhood for tax credit properties. And if you map where your tax credit properties are in Detroit and the surrounding communities, I would just bet you that a lot of them are in Detroit and not many of them are in surrounding suburbs, and let some families want to live in the surrounding suburbs and find the better schools and the better jobs that they think might exist there. They should have a choice. And so the idea is you can give higher points for tax credit properties if you're the housing finance agency that are located in non-traditional areas, or you could give higher points for tax credit properties that will replace current dilapidated, uninhabitable housing in communities of color. And maybe you combine it with economic development. So you put in something the neighborhood needs as part of it. I fought hard in some communities in Texas to get a grocery store, an affordable grocery store, and a CVS. I did not care about the Starbucks, I want you to know. Right? But you know, that would provide amenities for that neighborhood that I live near a neighborhood that never had a grocery store until white people moved in, right? So, I mean, you drive economic development by providing some market rate housing, and then suddenly people get over their racist idea and see a market. And those grocery stores are now that they've built in these communities of color serve everybody, and people drive for 2 miles away to shop there because it's the only decent grocery store in the neighborhood, a grocery store that didn't exist a few years ago. So combining affordable housing with market rate housing, combining it with economic opportunities, commercial, retail, whatever it is. I like an urgent care center because it always seemed like I was driving my daughter to an urgent care center for something. She broke her ankle, she broke her knee, fell down the steps, she cut herself. I wanted an urgent care center, you know, within easy distance of where I lived, and so does everybody else, really. I mean, I used to say I was a single mom with a teenager, and I wanted the same thing that everybody wanted. I wanted walking distance to a drugstore, a place I could buy a gallon of milk in case my car was down, or I wanted a place where my teenager could get an after-school job. I wanted public transportation nearby if my daughter was driving my car to California while I was stuck walking to the metro station. I wanted the stuff that everybody wanted. I wanted a hospital nearby. And when I think about it, I think that everybody, every family needs that kind of opportunity. And I like to think about the affirmatively furthering fair housing process. Now I'm way off target, but a rule that will come out, I've been told, in January after the election. No comment on that timing. But what it means is that everybody should be able to live in a community that they have access to opportunity. And opportunity is different depending on who you are. So if you have a person with a disability, opportunity means wherever you go for your dialysis or wherever you are working where you can get accessible transit, which is not necessarily everywhere in town. If you have a different kind of disability, maybe it is a place that's near your doctors and near the urgent care center. If you're a family with kids, you want to be a place where your teenager can get an after-school job so you're not worrying about them while you're at work. And you want to have a place where you can send them to the grocery store. Hey, honey, here's $10. Go up there and get a gallon of milk and a carton of eggs. I'll make you breakfast when you get back, right? That's what we all want. I'm just saying. All right. Onward and back to the actual topic at bay. All right, exclusionary zoning, so we're back to that. There's a whole range of exclusionary practices, and I guess I should say for the record, you can have exclusionary zoning that is not discriminatory. You can. I mean, exclusionary zoning at its bottom line is excluding one use because of the use that it is. But most of the cases that we deal with under fair housing mean exclusion of certain types of housing completely from a neighborhood or from a town, and usually it's closely associated with either intentional discrimination or discrimination that has an impact. All right, so you have a lot of different ideas about what can be exclusionary zoning and have a racial or ethnic impact. Here's some of them. Extensive single-family zoning in a town, okay? Large lot size requirements. You have to have at least 2 acres per one single-family house. Westchester County was a 10-acre site for a big house, right? That was minimum now. You could have 20 or 30, but you couldn't have less than 10 acres for a house. Limits on the number of bedrooms in apartments, so you can only have 2-bedroom or fewer units. 2-bedroom apartments are almost impossible to raise a couple of kids in with, I'm just going to say, especially when the kids get older. You can handle one, maybe 2 little ones, and then they start to outgrow the space, I'm just going to say. Moratorium on building new apartments. I've seen people do this, say we're not going to have any more apartments, no more multifamily. St. Bernard Parish, which was a subject of many lawsuits after Hurricane Katrina, one of the things that they did when you looked at their zoning map was it was a community of single-family housing. And they tried a bunch of discriminatory things. First, they said, if you're going to rent a single-family house, now remember, not too many apartments there. And so if you're going to rent a single-family house, you'd be related to someone who already lived in St. Bernard Parish. What percentage of residents of St. Bernard Parish were white? 93% of residents of St. Bernard Parish were white, so you'd have to be related to a white person to be able to rent there. What's the impact of that, I ask you? The court said, that's racially discriminatory. That's a racially discriminatory impact. And then they had another policy that required, there was a no Section 8 policy. So the Section 8 program in the New Orleans area was 85% black. And so by adopting a policy that no Section 8 voucher holders could rent any of the single-family houses, then you had a policy that had a disparate impact based on race. And then we started thinking, why doesn't St. Bernard Parish have any apartments? So we pulled out the zoning map, and guess what? It had this tiny, it's a pretty big county, parish it is, and this tiny little area over here at the bottom where downtown was the only place that they permitted apartments in the whole area. That's exclusionary zoning, where you don't have areas in a community that are zoned automatically for multifamily. Okay? Spacing or other restrictions on how many of X you can have in a particular space, especially for group homes serving people with disabilities. The spacing requirements are really common. You cannot have a group home within 1,000 feet of another group home. Okay? And you think, and Dan Lauber, if he were here, would be disagreeing with me right this minute, going, no, that's okay, because we want to spread them out, we want to make plenty, have some in every neighborhood and all of that. And then I say, but the problem is, if you're going to operate a group home, you first have to buy, normally, a residential, or lease, a residential single-family home, and you don't have a lot of money, so you're looking at only certain neighborhoods to start with. And then you want it to be on public transportation because none of the residents are going to have cars. And then you want a few other criteria like walk to the grocery store. And you've already suddenly limited your opportunities for where you could site group homes to a very small radius. And then if you say you can only have group homes that are not within 1,000 feet of each other, all of a sudden you can only have 3 in the whole town. And that's the problem with the kind of restrictive zoning approach that some people might use. Other restrictions on group homes, including there was one that required all this medical attachments and stuff for a group home that was going to house adult alcoholics who don't really need the exit from the second floor window or the smoke detectors or whatever it was else that they were requiring. Occupancy standards also can be in zoning ordinances. How many people can live in a group home? No more than 4. If you see a group home that is limited to 4 people with disabilities, call me, because I think that's likely to be an overly restrictive barrier to group homes to be able to afford to operate and to support. Like a lot of group homes have 4 to 5 residents to 6 residents, and then they have a caregiver. In fact, that's what we sued the Dallas Housing Authority. You know, with Section 8 vouchers, HUD has recently, in the last 4 or 5 years, permitted Section 8 vouchers to be project-based. And so you can project-base a voucher, the Housing Authority can, and put it in an apartment complex or in even a single-family house for a person. So we were trying to get, our clients were parents of adult children with disabilities who needed a less restrictive environment. What they needed to do was move out from mom and dad. They were in their 20s, some of them, or one was 40, and they'd been living with their parents their entire lives. They were capable of living on their own, but somehow it had never happened. And the parents finally figured out that their kids needed a more integrated environment where they could hang out with their peers instead of just with their parents. And the parents realized they were aging rapidly and needed to make other plans for their kids. And so the idea was they asked the Housing Authority to allow project-based vouchers, like 4 vouchers in a single-family home, 1 per each one of the bedrooms. If you get a voucher like that, you get enough money to pay the rent. And you might get enough money to have a little money left over. And then the individuals would use their Social Security income, part of their Social Security income, to help pay for a caregiver who would help them budget, make sure they got on the bus in the morning. These were people who could function well with some minimal supervision. And the Housing Authority refused to allow this, and we sued them and eventually settled the case for a settlement that has now gone into play, has been in play for many years, and which is housing people with disabilities throughout the community. Sometimes they'll project-base a unit in 2 or 3 units in an apartment complex. So that's a least integrated set. That's a less integrated setting than living at home. It's more integrated, and it allows you to interact with people without disabilities much more frequently. Same thing with single-family houses. And so that was not a zoning process, but it was a government decision-making process that needed to be provided to provide people with disabilities the opportunity to live in communities. Okay. Cool. Let me go through the justifications. Let's see. Where is it? Okay. I've given you some examples of exclusionary zoning. Here's a bunch more. Refusing to approve zoning for apartments unless restricted to seniors. I mentioned that earlier. Down zoning by reducing the scope of area zoned for apartments. Very common. Objecting to expansions of manufactured housing, which in many communities is affordable housing choice for first choice to buy a house for people who without a lot of resources. And a lot of those communities are nice as they can be, but the community opposes them. Many of them have significant populations of Latinos or black residents as well, so it turns into racism. And here's some of the justifications, and I'll sort of stop there, and then we'll take some questions and have some discussion. So here's some of the things that people have come up with in zoning cases to justify exclusionary zoning. School overcrowding, overburden the schools, I've already mentioned that one. And the question is that accurate or not? Is that true or not? In most cases, it turns out that it's not. Or that the schools may be crowded now, but by the time this property was built in 3 years and occupied, they were building a new school, right? So you go and look at that stuff. Water supply limits. Now, I know I'm in Michigan, so water supply is a touchy issue, right? But or other environmental factors. But what I find about this is the crowd raises it, but the municipal people just listen, but they never investigate it. And so if we get this as a fair housing case, we go investigate it, because the municipality is just seizing on these explanations. And yet, for example, if there were water supply limits, you would go evaluate how many people would be likely to living in this property and what impact. You go talk to the water engineers nearby, say what impact would have 200 more people in this neighborhood, and they say none at all. And then you write down in your notes, and then you go on your merry way. And so the cities they listen to this, but when they really are opposed to the housing, they never investigate it. And that's kind of a telltale sign. Budgetary and tax limitations, there's that. Preserve the community's rural character. Lack of public transportation. Now, I'm going to tell you a Grand Rapids story. There are Grand Rapids people in the room. So I gave a speech in Grand Rapids a few years ago, and we were talking about putting affordable housing out in a new area that had a Target and a high school. And I said to the crowd, big crowd, 200 people, I said, well, what's the biggest barrier to making this happen? With one voice, they said public transportation. There was no public transportation between this area and the downtown area where people were now living. So if you move out to the suburb, you take the risk and move out to the suburb for your kids' high school and for the jobs after school and for the walking distance to the carton of milk, you want to be able to get home again. If you didn't have a car, you'd want to have a bus. And the bus had to go both ways at the right times. It couldn't be a commuter bus just going in the morning and back in the afternoon. That wouldn't work, and never on Sunday. You had to have buses that would go during the weekends when people wanted to go home and go to church with their families or have a big luncheon together. Parking issues, big fight about parking always, and you have to justify that and identify what the parking issue truly is or not. They talk about public health and safety issues. Usually they talk about it, but it's not really justified. And then the generic concept of it'll be bring the criminals in and or crime rates. And I had the occasion recently, you can find crime rates online, and you go look at the crime rate for a particular area. You would be surprised how high the crime rate is in wealthy white communities as opposed to poorer black communities. Apparently because they have bigger stuff to steal out in the white communities. I don't know, but I think people raise this crime issue as like a red flag, and it's not always supported by the facts. It's not always crime, or it's not always crime in the particular area where this property might be located. And no real reason to justify or to expect that there would be more crime there. I feel like I've exhausted everyone. Are you awake? Yes? All right. Okay, well, I'll put up the maps that we can look at while we're talking.
Well, I think we have a few minutes for questions. Are there any questions from the audience?
So I know you are talking about zoning mostly. What about like HOA rules and things that are more like private covenants and things like that?
So HOA rules are covered by the Fair Housing Act if they are discriminatory. I live in an HOA, and it's quite a shock to my system to discover how rigid some of those rules are, even though I've had complaints against them for years. HOAs are covered by the Fair Housing Act, and they've been held liable for failing to address tenant-to-tenant harassment, failure to approve reasonable accommodations, failure to approve changes in the environment that is necessary for a person with a disability to live successfully, like declining permission to build a ramp at the front of the house, declining permission to put a fence around the backyard to serve the ESA that they also had a request for. They're liable if they, in the same way that municipal officials are, if they passed overly restrictive rules that operate to discriminate. Okay, what else?
Hi, I'm Allison Chavez. I work at the Fair Housing Center of West Michigan in Grand Rapids. Question for you, if, from an investigator standpoint, if you're wanting to look at exclusionary zoning as kind of a systemic issue, besides the probably incredibly dull and laborious task of reading through individual community, zoning law and regulations, do you have any ideas for some out-of-the-box strategies to identify communities that, might warrant a look, if that makes sense?
Interesting. It's a question of how to target communities that might have zoning problems. So first, I like the idea of RSS feeds and targeting, looking at the media reports. The other thing I like is talking to developers. I think fair housing community folks don't interact enough well with affordable housing developers, and whether it's through the State Housing Finance Agency, who might have a conference you could go over and talk to people at, or just individual developers, probably know neighborhoods or communities where they cannot develop housing because somebody they know tried it and it wouldn't work. And so, so they are the most valuable resources if you can get them talking. So my advice is go out and buy them a drink and get them talking. I'm just kidding, don't buy them a drink. But you could have a drink while they were having a drink. No, wait, I'm just not even advising that as a strategy. But I am saying that the developers who do affordable housing developers, and specifically tax credit people who do get a lot of tax credits, those are the ones that will have heard stories about particular communities. It wasn't worth their time to go and invest the often $100,000 or more to do a site plan and to take a look and to get an option on a land and think about what the demand was, because they were just going to get a no from city council. That's one idea at least.
This is Catherine Cooper with Michigan Department of Civil Rights. I have a question about, because in the state of Michigan, we do have some areas where we do have zoning that's not exclusionary. That's ordinances that are really good, very protective. But we have areas that were traditionally not, I don't know, a nice way to say, like, basically there weren't that many black people or people of color in that area prior. And so now that there are people of color in that area, sometimes I formerly worked with legal aid, there will be issues with enforcing those zoning ordinances where judges in district court would not enforce those ordinances and kind of side with
Against landlords?
Yeah.
Yeah, like code enforcement stuff, yeah.
Yeah, and to the point where like code enforcement was kind of literally ignoring interrogatories, ignoring discovery requests, and there was no support from the judiciary to like kind of enforce that on the district court level. And so my question would be like, what would be the next step in that area?
All right, well, I think the overall fix for that is use the new affirmatively furthering fair housing rule as part of, which calls for community input about various issues, including code enforcement and how it can be improved to protect the rights of tenants who are people of color. That's the long-term fix, because then you can have public input, you write letters, part of the AFFH process, your tenants come in and say they've complained to code enforcement 15 times and they still have mold and mildew, et cetera, et cetera. I represented someone who argued for adoption of the Uniform Landlord-Tenant Residential Act in the balance of the state. It was applied in the big cities, but not in the balance of the state, but to protect tenants for that very reason, because it allowed tenants to complain to code enforcement and actions to be taken, like withholding their rent, as a response to bad conditions. So, and it came up in an AFFH process, I'm going to say. So these are kinds of long-term remedies. On short-term remedies, I would pick a landlord who had a lot of code enforcements, who had a lot of black tenants, and I would file a Fair Housing Act complaint against them with lots of documentation, perhaps assistance from Fair Housing Allies, to say that basically the property was operating in horrible conditions because of the race of the occupants. And if you want to pursue that, come up here and get my card. On my website, of the firm's website, I am working currently on a HUD-funded, project-based X&8 property management company called Millennium Management that started with giving shitty conditions to black tenants in a place called Sandpiper Cove in Galveston, Texas. And after 6 years of advocacy, combined national advocacy on this, we have a Millennia Resistance Group, Facebook group, we have meetings once a week about strategies, and HUD is forcing Millennia to sell all of its properties off to other purchasers because of poor conditions for people of color. And so I can tell you about that case, and you can read about it on our website, and but I mean, it's a long, hard slog, I'm just going to tell you. But one or two cases where you document it from the tenants, do the tenant interviews, write up the lack of responses from management, write up the lack of responsiveness from the code enforcement. So you file against management, and you also file against the municipality, saying they're failing to provide code enforcement services for black rental tenants. And it's resulted in poor conditions and unequal terms and conditions of housing because of race.
So
That's
I think
my idea.
That's going to have to be our last question. Sarah, is it fair to say you might stick around for a few minutes?
I'll be here.
Okay. I know we can discuss this topic for so long, but the time has definitely come to an end. And so please help me thank Sarah Pratt for her time today. And thank